Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor, joined by Garry Chapman, police officer in Alabama. He is a very famous dad, Dog the Bounty Hunter.
That's right.
How was it like having a dad so famous?
You know, I don't have anything else to compare it to, so I guess normal.
Well, hey, if you compare it to my dad, you would have also nothing to compare it to because he wasn't around, but I digress. At least your dad was around. All right, look, so we actually just did a podcast with Dog, his dad, and it's fantastic. Look for that on the YouTube channel. So I said, while we're here, let's make some roadside chats. Mm-hmm. Okay, now this is an officer in Washington. Okay. So, but we're going to base this on federal law.
Okay.
All right. So the suspect is arrested for what? I don't know. He invokes his right to counsel, so he has an invocation. Okay. He is subsequently booked into the county jail. He's then released the next day. Now, detectives go back to his house, and they have a consensual encounter, mm-hmm. and they get a waiver, and they get a waiver, right? Mm-hmm. And they interrogate him, interview him about a completely different offense. Yeah. That's not the one about he was booked on. Let's say he was booked on DUI. Now they want to talk to him about a robbery. Do we have any issue here?
We got the 14-day rule.
All right. What's the problem?
So he's already invoked his right to counsel, and being that it's within the 14-day period, and he is not the one reinitiating the contact, it's gonna violate Miranda and the case law that follows it. So, yeah. I'd say everything that he says is going to be inadmissible.
I think you're right. I think we have a couple problems. Number one is we do know that Miranda is not crime specific, mm-hmm. right? So the Sixth Amendment is, right? So yep. This is not a Sixth Amendment question. So the Sixth Amendment, it happens all the time. Like people will get arrested for, crime A, and then the cop he'll invoke. Yep. He has a lawyer. Okay, mm-hmm. A lawyer's been assigned. He's been arraigned. Formal proceedings have commenced. But then different detectives want to interview him about a totally different crime, not intertwined with what he's... and we can do that. And we don't need to talk to his attorney because the attorney does not represent him on the uncharged offenses. Yeah. But the problem with Miranda is the U.S. Supreme Court made it very clear that it's not crime-specific. It's about all questioning, about all crimes. I like to say that once a person invokes Miranda, they cannot be questioned about any crime that they've committed up to that point in their life. Yep. Now, if they commit a crime in jail, there seems to be some courts, and rightfully so, that say, you know what, that's not. We can talk about the crime they committed. We can talk about the stabbing, or we can talk about the jail breakout. Yeah. But not about a robbery that happened 2 years ago. Mm-hmm. Okay, so that's the first rule. The second thing you mentioned is 14-day rule. Okay, so the 14-day rule is where the Supreme Court said, look. When a person, invokes their right to counsel, what they're telling you, they want to work through counsel. Yeah. Well, okay, so they can't get counsel immediately. Yeah. I mean, they might need some money. They need to start looking at the yellow pages. Do you remember what those are? You're kind of young.
Yeah, that's before.
You've heard it. Yeah, they had it in a history class. Yeah. They might look in the yellow pages and see, hey, Sal charges a good rate, and then they said, give this guy about 2 weeks to find a lawyer. Mm-hmm. And then they said, if he doesn't have a lawyer in 2 weeks, in other words, if you go back to him in 2 weeks and he either has a lawyer or he doesn't, mm-hmm. then you can basically reapproach him and look for a new waiver. Mm-hmm. Now, one thing you did mention as well, so we have a 14-day problem here. One thing you mentioned, which I like, is that you said reinitiate. Yeah. What do you mean by that?
So the courts have routinely recognized that if the defendant or the suspect in the case reinitiates the conversation after invoking Miranda, then it's not going to be a Miranda violation, and that's because he's asking to talk to you at that point, and he knows what's going to follow with that.
I saw a very high-profile interview one time, and the cops read him Miranda. This kid Miranda. Mm-hmm. It was a shooting, and the kid said, I probably I like to get an attorney first. He's being nice about it. He wasn't being like, screw you guys. He's like, I think I should get an attorney first. And the guy's like, all right, well, look, that's your choice, That means we can't talk to you. We can't even get your side of the story. And they're getting up. And he said, no. Look, I meant I will get an attorney later, but for now, I'll talk to you. And these cops are like, nope, you cannot change your mind. Is that the rule?
No.
He can change his mind?
Absolutely.
Look, we want to make sure we're clear. Hey, just so you don't have to talk to us. Give him Miranda. But I saw that. I'm like, kind of a rookie move, Yeah. And I understand with the cops, look, they're being overly cautious, high-profile case. But it's like, all right, guys, if you're working a high-profile case, that's especially important where you have to know the rules.
Oh, yeah.
Right? The guy can change his mind.
Mm-hmm.
Okay. Well, I appreciate you. Again, watch the podcast between Garry, Dog, his father, and me. We had a great conversation. And until next time, my friends, you stay safe.